All right, Appendix C, Part 242, CFR 49, Conductor Certification, Procedure for obtaining the Evaluation Motor Vehicle Driving Record. The purpose of the appendix is outline procedures available to individual railroads complying with the requirements section Statute 242, 109, and 2111. As the part of the provision required of the railroads, consider the motor vehicle driving record of the person prior to the issuing of him or their certification recertification as a conductor. To fulfill the obligation, the railroad must review the certification candidate as recent motor vehicle record of the generally with single record of the file will state the agency issued by the candidate current license. However, the included in multiple records and candidate has been issued the motor vehicle driver license more than one state agency foreign country. Access to the state motor vehicle driver license record. And the right of the railroad workers, their employers, and the prospective employers to have the access to state motor license vehicle license agencies concerning the individual driving record controlled by the state law. Although many states have mechanisms, though the prospective employers of the railroads can obtain that data, there are some states of the privacy concerns and so much access very different and impossible. Some individuals generally are entitled to obtain access driving record that will be relied on the state motor vehicle license by the agency taking action to concerned with the driving privileges. The FRA responsible individuals who want to serve the conductor as requested the current state driver's license agency further and such directly railroad consider for certifying the conductor. Depending on the procedures adopted the particular state agency, this will involve the candidates either sending the state agency a brief letter of requisitions executing a state agency accomplishing the same effect. They would normally involve the pay of the nominal fee established by the state agency for the such records. Check in the rare instances with certification candidate has been as multiple licenses and may require more than a single request. One of the railroads has obtained motor vehicle record. The record must be afforded with the prospective conductor approximately to review the record, responding to the rating in context, avoiding the provision of 242-401. The review of the opportunity must before railroad evaluates the record. The railroad evaluation subsequent decision make must be done with compliance with the provision of this part. Appendix D, Part 242, Medical Standard Guidelines. The purpose of the appendix is to provide with the guidance that the procedure shall be employed with administrative vision and hearing requirements of Statute 242-117. Determine whether the person of the visual acuity meets exceed the requirements of the following of the test protocol deemed the acceptable methods determining the person's liability to respond, recognize and distinguish among the color signals of the railroad industry. Acceptable test method is in the left-hand column. The criteria shall be employed to determine whether a person has failed a particular testing protocol as shown in the right-hand column. Accepted test and failure to criteria. American Optical Company 1965, 5 or more error plates on 1.5. The AOC Hardy Rand Ritter plate, second edition. Any error on 1.6 plates 1.4 are demonstration of the test plate of 1 actually in the 5 in the book. More visions test. The Keystone Author any error shows like plates. In administration, these protocols conducting the examination should be the railroad signal and do not allow the same sequence. The yellow signals do not allow to appear the same. This is not acceptable. The yarn other materials cannot simple test whether the certification candidates request the vision. No person should be allowed the chromatic lenses. Be allowed to wear chromatic lenses during initial persons for color vision. The initial test conducted in accordance with the accepted test in chart of 242-117H3. An examinee would follow the criteria of the chart by the evaluated determined by the railroad medical examiner. Ophthalmological referral field of testing, particular color testing, ultimately utilized depending on the experience of the examinee. The railroad medical examiner will view all the pertinent information under some circumstances. May restrict examinees who does not meet the certificate on serving the conductor neither during reverse the conditions under the circumstances. The intent of 242-117 is not to provide examinee with the right of the infinite number of the requests of further evaluation, but to provide examinee with at least one opportunity to provide hearing revision. Failure does not meet the examinee cannot safely perform as conductor. Appropriate further medical evaluation could not provide another scientific screen for the field of tests. Although the railroad should retain the limited number of the retest, examination can request any cap of the number of the retests should not be the retesting change circumstances which make the retesting appropriate. Checks the circumstances would be not likely to be occur if the examinee's medication has improved. If the examinee's medical condition has improved in some way, the technology advanced to the extent of the arguable could compensate the hearing and vision deficiency. Conductors who wear contacts should have good tolerance for lenses and should instruct with a pair of corrective glasses available when on duty. Okay, Part E, Appendix E, the two-part, Appendix E to 242, Appendix of revocable events. Your first is a signal requiring complete stop before passing. 2. Restricted speed over 10 miles an hour. Required air brake test and occupying main track authority. Disabling a safety device. Shoving a movements. Equipment following adjacent tracks. Hand-operated switch crossovers. Hand-operated switch connected to the main track. Hand-operated crossover switch before and after the movement. Hand-operated derails. And 12. Drug alcohol. 1 through 11 can give you in first offense a 30-day revocation on the main track, 6 months, and second offense in 24 months. Third offense in 36 months, 1 year revocation. Fourth offense within 36 months, 36 months. Drug and alcohol, different periods for the revocation may be applied. Other than main track restriction speeds, operational effects non-offensive for the previous 12 months. 1 through 5 is not applicable, while 6 through 11 have a half revocation period, not applicable, and a half revocation period. The main track, other than main track, offensive as a conductor and offense as an engineer. The engineer may not be working as an engineer during the period of revocation, and employee may not work as an engineer during the period of revocation. An offense is an engineer, an employee may not work as a conductor during the period of revocation, not applicable, and an employee may not work as a conductor during the period of revocation. And this was this is issued by Washington, D.C., October 2011, Joseph C. Sabo, Administrator of FRA Docket 201-21875, filled 11 November 8th, 2011, 8:45 a.m. Publication date 11/9/2011. And once again, that is the Department of Railroad Transportation Federal Railroad entitled CFR 4 Part 242 Conductor Certification Federal Railroad Administration Final Ruling.